what I've done is, for the reading, I'll give you something that I wrote that I hope helps understand definition and privacy, how they overlap, and also will provide you with some foundation for the tort assignment, which is due sometime. So tort, whenever I teach Canadian tort, I'm usually in Toronto, and I find driving in Toronto induces a feeling of committing tort. Intentional torts. I don't know, it's not like people in Europe are superb drivers. They're just really odd people here.
Yeah.
With
And
driving.
nobody knows how to drive.
Like, the ones that won't have to do a U-turn in a 4-lane street from the furthest lane over in heavy traffic. I have just a special brand of, well, I hope they go to a special place of hell. I don't think Dante contemplated a circle of hell for those people, but there should be one.
Well, there's a spot,
Only the door.
there's a spot for Uber drivers.
For Uber drivers.
You know, functionality and all that.
Next to that, but let's go through it.
So we're looking at tort, and I'm looking at the, I think the file is Introduction to Tort. So I'm looking at that file. And you have a definition, the law of tort is concerned with common law wrongs other than breach of a binding promise. So part of the difficulty when we look at obligations in the common law system is contract seems to be more easy to understand, relatively speaking, because people agree to certain parameters, but tort is sort of what's left over when something, when a wrong is committed. And the idea of a wrong is sort of, there's not a set down definition of what is a wrong. And we'll see that, I think, in particular with negligence and with privacy and defamation. So the two kinds of torts, intentional torts and negligence. Intentional torts, the defendant intended to commit the tort action. And we'll look at that a bit later. Negligence is where the largest part of the cases are, and that'll be the dominant area that we look at starting next week. Moving to the heading, the bases for imposing liability in tort. So the way we're looking at tort is, at first, is looking at some of the language the terms that come about. And one basis for imposing liability or kind of liability is absolute liability, which no longer is the case in Canada, if you remember from your constitutional court. If you remember the case. Sault Ste. Marie.
Sault Ste. Marie. Sault Ste. Marie.
Traffic. I thought it was a traffic.
Yeah, classified traffic.
Yeah. So we don't have absolute liability because absolute liability just means you commit the wrong and it doesn't matter why you do it. So if we think about trespass to property is an intentional tort. If you intend to step on the property, that would clearly be intention, but what if somebody pushed you? Well, absolute liability would say, you're liable anyway, it doesn't matter how you got there. So the most strict version of liability that we come across now is strict liability. And the idea with strict liability is that maybe there is some kind of a defense available. So the classic example, I think, of strict liability, and I've taken it out of the course this year, sort of the property torts, what I call them. But I give you an example of it here, Rylands and Fletcher. Have you heard of this case? So Rylands and Fletcher is a landmark case from the 19th century, which basically says, if you bring a dangerous substance onto your property and allow it to escape and it causes damage to your neighbor's property, then you are liable. And that was established in the case called Rylands and Fletcher. But over time, the English courts have modified that. They've actually brought in an element of foreseeability. So they've weakened the strictness of the liability to say, well, there should be some sort of foreseeability, which is not really part of strict liability. So when we talk about strict liability, we just mean basically you committed the wrongful act, like absolute liability, or maybe there's a basis for the chance for defense. Another topic we won't cover is vicarious liability. And for our purposes, vicarious liability is simply if an employee commits a wrong, a tort wrong, then the employer is responsible. So a FedEx driver, as they tend to do, strikes a pedestrian. It's not the driver's fault, it's the company's fault. The company stands in the place of the driver, as long as the driver was going about his or her work duties. Now there are different tests and so on, but I don't think that it's as useful for us to spend time on vicarious liability as it is for the other areas that we're looking at. Then we have negligence. And the key difference between negligence and intentional torts is you don't have to prove intention in negligence. You prove that the defendant failed to take reasonable care. So we've talked about deceit before. So if you're going to try to prove the defendant was committed the tort of deceit, you have to establish that he or she intended to deceive. And that's a difficult threshold to meet unless they admit it. Because it means you have to find evidence that shows that they intended to deceive. So in the alternative, you would take the action, the negligence action of negligent misrepresentation instead. That they were careless in some way or didn't take reasonable care. And they were indifferent to what happened. So that takes up negligence and intention. And then we have the concept of no liability. And we don't really have a lot of cases on this. I've given you Allen and Flood. But the idea is that not all types of harm lead to tort redress. So we can sort of say hurt feelings, there's no action for hurt feelings in tort. Part of another layer of the difficulty of tort is what is its function? And this is where we have these different functions from compensation, punishment, deterrence, justice. But they don't all necessarily come up in each case. Sometimes they can be a bit contradictory if you're looking for all of them in one case. Largely, tort cases are about compensation. putting the victim in the place they would have been in, they were in, sorry, had the defendant not committed the wrong. Whereas in contract, if you're suing for breach, for example, the innocent party is saying, I want what was owed to me in the contract. So what you're putting the innocent party in the position they would have been in had the contract been performed as it should have been. So compensation here, using our FedEx example, compensation would include what, do you think? What are you compensating the victim of the FedEx driver striking on for?
Their health.
Sorry?
Whatever happened to their health. No?
Okay, so personal injuries,
Less salary or whatever.
so it can get very expensive when you break it down. Because if the person suffers a permanent injury, the compensation would have to take that into account. So it may necessitate a change of jobs or a modification of work. How much time is lost from work if they can return to work. Maybe homes have to be modified. So when we're looking at compensation, it's quite wide what the spectrum can be based on the injury incurred. What we see to a lesser extent, I'd say, is punishment or deterrence. I think the best example of these elements in court comes from the United States. I think there's a difference that has to be kept in mind when we compare, let's say, Canada and the UK on one side and the US in terms of tort on the other. And that is, in the US, tort damages are often made by juries. So, everybody has a story about an outlandish case. The one I think most people remember is an older woman in McDonald's who spilled her coffee on her and suffered, I think it was third-degree burns. And she got, I think it was double-digit million.
Yeah.
For that. Now you can say, well, surely her compensation, that's beyond what she needed to be compensated. Surely she didn't suffer losses to that extent. But part of the award is to make an example out of, in that case, McDonald's. That McDonald's or whatever, usually it's a company, whatever company is a defendant, that they need to take better care. So juries in the US will often make an example of these individuals and say, well, just to make sure you don't do it again and everybody else knows how bad this is, here's 20 million. In Canada, we don't really have that, and nor do you have it in the UK. So punishment deterrence can still be awarded. We can award damages, for example, but that's the rarer case. And then with tort, there are theoretical perspectives. And I didn't really add this in to contract because it's not really taught that way, but most tort textbooks talk about the theories behind tort. So you have rights-based and social welfare and so on. Law and economics is very popular in the US. So the right-based I'll focus on, and then I'll look at corrective justice. Rights-based says that the parties are joined in a private relationship with correlative rights and obligations. A tort consists of the defendant's failure to honor an obligation and the concomitant breach of the plaintiff's right. So it's a vindication of the parties' moral relationship. And tort is recognizing and enforcing individual rights. So again, with our FedEx example, pedestrians or anyone walking in Toronto has a right not to be struck by a FedEx truck. We don't have to put that down in legislation or anything. We just kind of know that through tort law, that we have these basic rights that are given effect when they're violated, and they're recognized through the courts. Now, corrective justice is a different perspective. And in Canada, a leader of this has been now an emeritus professor at University of Toronto named Ernest Weinrib. And I mentioned this because the Supreme Court of Canada has endorsed corrective justice as the theory for negligence. But they don't explain themselves. They did this in a case called Clements versus Clements that we'll see in causation. And corrective justice, if we take our FedEx example, corrective justice is upset with what happens in the orthodox setting of our FedEx example. First of all, it's upset that the employer would have the responsibility and not the driver. Corrective justice says there are these straight lines. The driver committed the wrong, not the employer. The driver should have to pay for it. And sort of underlying it is this idea of, people will take better care if they are personally responsible. And Weinrib was a philosopher, and then he did a law degree. So I think he specialized in Immanuel Kant, if you're familiar with Kant. So a lot of what influences his idea of corrective justice is what they say is Kantian. Now, the converse to corrective justice is something called distributive justice. Distributive justice, using our FedEx example, is what we currently have, the system we have. So either vicarious liability where the employer absorbs the loss, or let's say the FedEx driver wasn't on duty, he or she was just driving his or her own car and struck someone. Then you have personal auto insurance. And distributive justice says no one person can bear the cost of striking, for in our example, striking a pedestrian. Let's say you strike someone, a friend of mine, just to give an example, she was riding her bike at Bay and Yorkville, and a driver wasn't paying attention and hit her, and she was on her bike, and broke her pelvis. So, like, she's never recovered, and life is kind of painful. So just use that as an example that if you strike someone with your car, it may not just be a bruise and somebody can get right back up. The damage, so to speak, may be remarkably extensive. So the thinking with distributive justice goes, no one person could possibly pay for that. It would bankrupt them. And arguably leave the victim without at least some form of compensation. So we have insurance, auto insurance, that distributes the risk of car accidents amongst, let's say, 100 people are in a plan. So everybody pays into it. Hopefully, not all 100 get into an accident at the same time. And what one does, then the insurance company draws from that pool, and everybody can kind of carry on with their lives to a certain extent.
Whereas corrective justice would argue that,
You did it, you pay. You break it, you pay.
and it's from a consequential point of view, like it's better because we have better consequences, or because
Yeah.
of the,
I think underlying it is this idea of a deterrent. People will be more responsible if they have a personal stake. So the person that I was talking about at the start, that does a U-turn on Yonge Street from one lane going southbound all the way to the other side going northbound, that person may think again if corrective justice is the tort concept we employ. So there are different ideas that come through in tort, different philosophies that underpin what is happening in tort. And I point that out to you because there's not really one consistent theory that is employed. And on top of that, there's a debate about what theories are best to employ. For our purposes, I don't expect you to necessarily get into them. You don't have to email Professor Weinrib and let him know you want to learn more or anything like that. It's just to basically set out some of the informing theories before we get into things. Any questions about what we've covered so far with the introduction?
You said corrective justice was decided
The Supreme Court of Canada in 2012, in Clemens versus Clemens, said the approach that we take for negligence is corrective justice.
But that's not in practice. That's not exactly what happens.
Well, arguably, if the Supreme Court says it, it's in practice. My question is, I bet you most lawyers in the country don't know what corrective justice is. I bet out those, almost 100% of them don't care. So it presents a problem. What is the Supreme Court doing with this? So I'm letting you know, because I think it's better to learn here than on the job, and just flagging a point, and we'll see it when we come up with Clemens versus Clemens.
So do you think that if you go down that road, you say following corrective justice,
Sorry?
do you feel that if corrective justice at the end wins the day, all personal injury lawyers are unemployed, or it almost seems as if they make their money based?
I don't know, like personal injury, I guess, I don't see it ever going the other way. Because for automobiles in Canada, we have, sorry, at least in Ontario, I don't know about Canada, we have no fault insurance. Which means somebody hits you, it's nobody's fault. Which, having been in an accident where this old lady ran a stop sign and hit me, I wasn't too fond of it. Because I'm pretty sure I can prove that it was somebody's fault and it wasn't mine. But no fault means nothing. Like you don't get. The bigger problem people have is trying to get the insurance company to pay for their injuries.
And the concept of corrective justice would almost undermine.
Yeah, but it would require a reversal of no fault insurance. No fault insurance, if you follow it philosophically, is almost antithetical to corrective justice. Because it says it's nobody's fault, and corrective justice says, I think there's fault. Right? Any other question?
Well, if I was just add, in Ontario, you can still sue for general damages.
In automobile accidents.
In automobile.
Yeah.
If you surpass certain thresholds, monetary
Yeah.
and verbal. In Quebec, it's 100% no fault insurance. There's
Yeah.
no tort action for for personal injury.
Yeah, so I'm not trying to overstate what it is in Ontario. I think the way the system is set up is, it's called no fault. You can get more money if you sue, but there's almost a disincentive, I think, because you have to bring the claim and so on.
But essentially, retroactive justice, I understand, is you still sue the tortfeasor.
Yes,
And if there is a policy of insurance covering you for the negligence, that comes out of the policy, be that as it may, the damages are so huge, they will deplete the limits of the policy insurance for the rest.
yeah.
That's the tortfeasor per se responsible.
Yeah, I think corrective justice understates what's happening. Again, using our automobile example. If you get into an accident, usually your premiums go up. You are paying to some extent. So it's not like somebody gets away without any responsibility. And also, you know, maybe tort doesn't factor that in, but yeah, if you cause somebody harm, there, I think, would be some sort of personal sense of responsibility to it. That's outside of tort. But it's not like somebody goes away all happy, I hit somebody. So I don't want to give a false impression that way. Nicholas, you have your hand up.
Yeah, can you just briefly explain what the term no fault insurance means?
So if you hit me with your car, let's say you go through a stop sign, no fault insurance says it's nobody's fault. So I don't sue you for what happened. My insurance company takes care of it.
So it's only for personal
Oh,
injury.
Yeah.
you as
Only
the
for personal injury.
Yeah,
Not for property damage.
yeah,
That's a different kind of story.
yeah,
You're saying you're the victim, but your insurance will pay.
yeah.
Okay, I understand.
And then if there is a fight as to what happened, usually it's the insurance companies going after each other.
Okay.
So if anybody works in personal injury or insurance, you're probably more familiar with it than I am. I stay away from insurance.
Well, no fault also means that if someone doesn't have insurance at all and gets hit by the car, can still claim accident benefits from the insurance policy that covers the car.
To some extent, I don't know how it works though with criminal law, because you have to have insurance in order to drive,
Not as a pedestrian.
okay? In that case, yeah. I
You're
thought we were
covered by
talking
the-
about somebody just driving along. So, the basic concepts of remedies in intentional tort. I talked a bit about compensatory damages, and we have these subheadings of personal injury, general damages, aggravated damages. Punitive or exemplary damages are what I was referring to with the McDonald's coffee cup case. You're punishing the defendant or making an example out of them. Those are generally not awarded. And then we have this idea of nominal damages that comes up more in intentional torts. And nominal damages can be something like $1, $5, a nominal amount to recognize that a right has been infringed. So the court is recognizing that a right has been violated, but there's not necessarily maybe any loss to it or anything significant to it. For example, we think of trespass to property. Somebody steps on your property, technically that you can sue them in tort. But what you would likely get if they didn't cause any damage is an award of nominal damages to recognize the right was infringed. So I'm going to move down to the intentional torts now. And start with battery. Because I think getting into the intentional torts will better explain some of what we're talking about in tort in general. The tort of battery. So with all these intentional torts, you're looking for what are the criteria to establish a claim. For battery, it's intention and direct contact. And that it was unwanted or harmful to some extent. So we have the case of Bethel versus Yin. What happened in this case? Bethel versus Yin.
So someone grabbed somebody by the collar with hands and shook him, and then his head struck the other person's nose. And the question is whether the injury that the plaintiff sustained from this striking was within the intention of the defendant. And yes, they said it was because he intended to shake him, and then something that is very likely to happen. The consequence is falls within the intention.
Yeah. So this is a minor is hurt in this. I think that this is a store owner, and he thinks a minor has done something in his store, and he gets the kid and he shakes him, and in shaking him, he got too close to the kid and broke his nose, I think it was. So the idea is the shop owner will say, well, hold on, I didn't intend to hurt him. I didn't intend to break his nose. So you couldn't possibly sue me for battery because there was no intention. And the court says that doesn't matter. And Constantina told us why. That is that the shop owner intended to grab the kid. And anything that comes about through that, the shop owner is responsible for. So if we put it another way, if you're representing the shop owner and you say, well, he didn't mean it, that's not a defense. Your client is still liable in battery. So what do we take from this for battery? Well, you don't have to necessarily foresee what's going to happen. There's no foreseeability because the argument of Yim is, I didn't think that this would happen. So the focus is on, did you intend to, in this case, grab the kid? Yes, that's enough for battery because it fits the criteria. An intention to directly contact someone and it was unwanted or harmful in some way. Now, we talk about harmfulness or unwanted for a reason. And imagine if you're at the Eaton Center. There are torts of battery committed every hour in the Eaton Center. If somebody comes into contact with you, you can say, well, they didn't mean to bump into me, but they intended to walk that way, is sort of the idea, and just incidentally bump into you. Is that a battery? No, because for battery, it has to be beyond this level called de minimis. You might have come across this term in criminal law. De minimis means beyond a minimum threshold. So you can't sue people for bumping into you along the Eaton Center. But if somebody strikes you, hits you with their fist, you can sue. That is beyond de minimis.
Or pushes you,
Sorry?
or if somebody pushes you, they
Yeah. So, battery is usually packaged with assault. And Nicholas, I think, was the one that talked about the overlap with criminal law. And I expressed some caution for that. This is one example where that overlap doesn't help or maybe can be confusing. Because I think the criminal charge is assault. So if you hit someone, you're charged with assault, but the tort concept of assault is not the actual striking. That's battery. Assault is different. If we think of assault, it can, and battery can happen this way. If you're looking at someone and they're running at you with their fists pulled back, that can be assault because it is an intentional act by the person and you feel some immediacy of harm, actual harm. And if they follow through, then you have a battery. So that's why I'm saying you can sometimes package assault and battery together in tort. But keep in mind that the terminology is different from criminal law.
I was gonna say, kind of remind me of that British common law case about phone calls, right? Remember that one?
Another one?
It was the one where
Alberta.
Ireland
it was the one of the, it was like a UK common law too, where the man used to make phone calls.
and Britain.
The woman is pretty much threatened her over the phone.
Yeah, I think, well, we touched R versus Ireland.
I think, yeah,
Ireland
that's
and
the one.
Burst, so, yeah.
Yeah, I think, do I have it in here? No, I don't. Yes, I do. Yeah, so I'll come to that in a minute. So, Stevens and Myers. Can you, the question here is, can you sue for assault if they didn't hit you? And the court says yes. Because assault is the other person is intentionally coming at you and you fear immediate harm. So in this case, the plaintiff was never hit by the defendant, but the defendant lunged at him. Now, we focus more on the idea of physical harm. Assault has been expanded somewhat to include words. So Reed and Coker is a case that came up when mining was a huge industry. The defendant's workforce surrounded the plaintiff, rolled up their sleeves, and threatened to break his neck if he didn't leave. Is that assault? The court said yes, because there was a fear of immediate harm. Tuberville and Savage is a case that you see in all the tort textbooks, and it's sort of interesting because Tuberville says to Savage, he puts his hand on his sword and said, if it were not a size time, I would not take such language from you. Is that assault? The court said no. Because Tuberville, in more modern language, was basically saying, if it wasn't summertime, I wouldn't take that from you. But it's summertime. So you couldn't possibly fear immediacy of harm. is the idea. And then the Ireland case that Balcar had mentioned, this came in the context of Ireland was an accused who had been remanded for trial, and he had telephoned a witness. I don't know how he got the number, but he telephoned a witness, didn't say anything, but breathed heavily into the phone. And the court said, well, this constituted assault because there was a fear of actual bodily harm. Now, it kind of toys with the idea of the immediacy, right? Because in the other examples, it is quite immediate at that moment. In Ireland, the immediacy of the harm was expanded. And I think, or I hope at least, we can kind of understand why. And that is, if you're a witness in a criminal proceeding and you get a phone call and somebody's breathing heavily on the other end, that's fear-inducing. You're fearful for your personal safety. Let's go down to Borman and Grosvenor. This is an Ontario case from this century, happily. The defendant posted 14 threatening and defamatory messages on the internet over a 2-year period that, among other things, called on the public to harass and physically assault the plaintiff. And you can read on to see what else he did. So this was found to be assault for our purposes and defamation. So the modern context, we could say, is if somebody posts threatening messages on their Twitter account, I'm going to get so-and-so, that could constitute assault. Unless you're the President of the United States. So then we have false imprisonment. False imprisonment, again, don't take it as a criminal concept. This isn't about you were falsely accused. This is about a restriction of freedom. So the criteria, there is an intention to restrict someone's freedom, and there was restraint. There's a question as to whether or not voluntariness is an element. So let's look at Bird and Jones. I'll give you a minute to take a look at the case. Bird versus Jones. I think the further facts to this were that this took place in London, and the individual wanted to cross a bridge from one side of London to another, and was stopped from crossing that bridge, and said, well, I was falsely imprisoned on the south bank of London. And the court said, no, you weren't falsely imprisoned. You had a route cut off, but there are other bridges that you could take to cross to the north side of London. And the principle that comes from this, I think, is the more useful point, that restraint has to be total. A partial obstruction of a right-of-way is not false imprisonment. Otherwise, obstruction would constitute false imprisonment. Campbell versus Crespi. this is an interesting variation to false imprisonment. The issue was whether or not Campbell was falsely imprisoned by Williamson. And the court says she was. But she wasn't physically restrained. Williamson didn't block her way physically. He didn't do anything to block her from leaving the store. But Williamson used his authority, and because of that authority, Campbell thought she couldn't leave the store. So here we have, I've written the rule, the person is intimidated by a show of authority, afraid of the consequences of refusal, or apprehends the use of force, or is seeking solely to avoid the public embarrassment. He may be imprisoned, and the defendant will be required to justify the detention on the ground of her legal authority to arrest the person. So a police officer detaining someone, arguably that's falsely imprisoning someone, but that is lawful. Here we don't have the same circumstance. Here, Campbell felt she was restrained from going anywhere but staying put by Williamson's use of authority. So this is all on an objective assessment. It's not that Campbell says, I felt as so. It is objectively the court can see that a reasonable person, and this is a concept that comes up frequently in court, that a reasonable person would have felt that they were restrained from leaving the store by Williamson's authority. Now, a variation, I think, on that concept is heard in Weirden. And the issue here is 20 miners go down the mining shaft to work. When they get down there, they are fearful for their safety. And they ask the employer, can you send the elevator back? Because there's only one way in and one way out. It's through this elevator. And they don't send it until the end of their shift. So I'm not sure how long they were down there. Let's say it was several hours. They felt unsafe, they wanted out, and the employer didn't send the elevator down to retrieve until the end of their shift. Is that false imprisonment? The case says no. Why did they not find it to be false imprisonment?
He agreed by entering the employment contract.
Yeah. Now,
Isn't it the same as entering into trains?
it's a bit different. Like there you have like a license or permission granted. Here, the idea is, well, you're a minor. You consented to be in this confined space at the bottom of the mine shaft. You can't say that you were falsely imprisoned because they didn't send the elevator to you when you wanted it. Now, I think we can sort of push back on this case. And I mentioned this not to say that Heard is wrong. Heard is the way it was decided. It was House of Lords, I think, wasn't it? Yeah. But I think just, sorry?
In 1915.
Yeah.
100 years before maybe a similar case.
That, but also I think you have to look at it in the historical context. And sometimes, I mention these because sometimes it's important. Remember Stilk and Myra in contract law. We were talking about it with consideration, where there were 11 crew members and 2 deserted the ship, and the other 9 were told by the captain, I'll split the wages, and then didn't. Yeah, I was joking. So And we found in that case, the House of Lords said, we're deciding this in part on public policy reasons because we don't want crew people to hold captains for ransom. And at the time of Stoke and Myrick, ships were essential to commerce. Well, 1915 or early 1900s England, mining is crucial because everything runs on steam. And coal mining is essential to that endeavor. So I think we also have to look at that the courts are factoring that into their decision. I don't think it should escape you that both were sort of employment type situations. For whatever reason, the House of Lords is afraid of employees doing weird things. So I think we can push on the Heard and Weirdale decision and say, well, if they were afraid for their safety and you left them down there for several hours before you sent the elevator down, maybe there's more of an argument there than you're allowing. Yeah.
Is a threat of force not actually, I'm looking at the false imprisonment requirements, it's intent, restraint, and then you've got a note impeding progress may be imposed by barriers, other physical means, and implicit or explicit. Those are presumably just illustrations. Or would you argue that a threat of force might be the person may be fired or whatever the case may be? I mean, it seems to me to be a labour dispute and has nothing to do with false imprisonment.
How not false imprisonment?
Because there's a dispute about whether or not the conditions are safe.
Right, but if you're keeping people, if there's somebody saying those are unsafe conditions and you don't agree, that's one thing. But if you're keeping them there.
Well, it's part of their job though. They go and yes. I mean,
I don't want to work for you.
Sorry, I'm a defendant.
Oh, you were tough on Uber drivers too, you know.
I'll come to you in a minute. Just give me a minute. See, I think I would say at least we differ on this. That, for example, was the case we've just done, Campbell and Kresge, gives us this idea. I know it's a lot later in terms of time, but these torts are being read kind of expansively in some situations. Campbell being one, where it's not necessarily somebody is physically constraining you. With Heard, arguably, these people are in an unsafe place and cannot get out. And the only way to get out is controlled by these other people. So that's why I think at least the argument about false imprisonment could be made. They were unsuccessful, but I wouldn't read this as exclusively a labor dispute. It may have been part of an overall thing, labor unrest, but that I don't think that takes away from the possibility of the arguments put forward regarding false imprisonment and the tort aspect.
Okay.
As I said, I think we differ on it. Yeah.
I wonder whether how this case is different from the case shortly behind it, the Robinson and the Bowling case. That case, you pay, get into the gate, and then you have to pay to get out of it. If you don't pay, then you cannot claim false imprisonment. So I mean that by analogy, this case you get to the mine voluntarily. Then
let me put it to the group. How is the next case, Robinson and Balmain, different from Heard and Weirdale? That's the question that was asked.
Which case are these on?
Robinson versus Balmain as compared to Heard and Weirdale. So what's the difference here?
Well, Robinson had a way out, just a penny and you're out.
Okay,
The
He
contract,
was not held under any circumstances. He had an opportunity, like the case with the bridge. There was an opportunity for him to go out, no questions asked.
sure, but they weren't letting him out until he paid, right?
yeah, but then you have
So
to
you put
pay
the penny
twice,
and go.
basically. The contract was original that you pay when you go in and you get back your money when you go out, no?
No, you pay, a penny is paid by those who enter, and a penny will be paid to exit.
Yeah, so there is no.
So he went in, he went, let's say the York subway line. He went in, remembered, oh, I need to go somewhere else first,
Oh,
and wanted his penny back, 1910.
okay, yeah.
And they said, you can't get out until you pay a penny.
So I think that the difference is that at Robinson case, so it was up to him to pay the penny and go out of the seat. At the Herb case, the minors couldn't go out unless the manager sent back the elevator. So they didn't have an option.
Okay.
Yeah, when you have an option, then it's not a total decision.
Yeah, but that, well, again, in Robinson, they're still keeping the guy there until he pays a penny. So I think I have the holding there for you, quoted from the case. There is no law requiring the defendants to make the exit from their premises gratuitous to people who come there upon a definite contract which involves their leaving the wharf by another way. The idea here is there's sort of this mixture of contract and license. There's a contract between Robinson and Balmain, and Robinson has a license to use this property for the duration that he's using it. But the part of the contract is you pay a penny to get in and a penny to get out. So the court is saying, because you refuse to pay the penny to get out, does not mean that that constitutes false imprisonment. Because a requirement of false, this isn't false imprisonment, they're saying. Because you can get out, you just pay a penny. And that's part of the contract for using this area. Whereas in Hurd and Weardale, it was different from that. The way the House of Lords, I think, looked at it was, you agreed to be a minor, you're down at the bottom of the mine shaft, you're not falsely imprisoned. And my criticism of it was, well, if they felt unsafe there, is, I think, maybe too little regard was given to the minor's argument. But still, the decision was there was no false imprisonment. Does that deal with the difference?
I guess the mining, the safety
Yeah.
conditions that time
Well, like
could be quite tough.
there's a reason why trade unions came up
Yes.
during the Industrial Revolution.
Yes, and also the court argued that the management knows,
Yeah.
right, better when that is not so sure.
No, well, like today we might have a different view.
Yeah.
Then it was a bit more, the paradigm was master-servant. Any questions so far? Yeah.
The third point on volition, then.
See, this is what I'm not sure about. So, false imprisonment. I'm just looking at what cases we have.
Bird, Campbell.
So, under there's a question I put to you, must P be aware that he is being detained? It's above Robinson and Balmain. And you have the case Miriam and Graham White.
sorry, that case is.
So, yeah, you have it, right? No?
Yes.
Is it Meering versus Graham White? Okay. So this case, the person that was falsely imprisoned was not aware of it. Let's say they fell asleep. You fall asleep in their class, and I lock the doors. Are you falsely imprisoned? Meering versus Graham White says yes. So the question is, what is needed for false imprisonment? Do you have to be aware?
Yeah.
And that goes to the idea of nominal damages. That if you were asleep and I locked you in,
Yeah, there was no harm.
you might get nominal damages to recognize that your right was violated, but not more. That's kind of what I'm looking at here. With that element of false imprisonment. And it's unclear. So if it was a question, if I gave the example I just gave on an exam, you can say, well, there could be a question as to whether or not you have to be aware, but what's more likely is that, and we use the cases to support the idea that a right was infringed, and that the damages would likely be nominal. So let's take a break and come back at 7:40. A criminal case against someone.
Repeat it.
Malicious prosecution is looking at whether or not we can sue the Crown for bringing up proceeding against the individual.
Yeah. Sue somebody for malicious.
And the landmark case is called Nellis versus Ontario. So it's worthwhile looking at the history of this because it's important to the case. So the Attorney General at the time was Roy McMurtry, who the park outside is named after. And he had brought this case against Susan Nellis. What had happened was, at the Hospital for Sick Children in Toronto, I think it was about 6 babies had died within a couple of weeks. And they all died of the same reason. And suspicion fell on the nurses. And for whatever reason, Susan Nellis was pointed out. And so the police went to her home to interrogate her and so on. And in her pocket, she had the card of a lawyer. The police took that as a sign of guilt. So she was charged in the deaths of these children. I think the way it was her father was a doctor and her mother was a stay-at-home mother. The family savings was used entirely on defending her. So she wasn't getting a lot. Her father's savings was put towards defending her. The charges were brought in first-degree murder. Oh, sorry, 4 babies. The charges were dropped eventually at the preliminary hearing. So it didn't go to trial. At the preliminary hearing, the charges were dropped. So if you're Susan Nellis, you have a problem. You have no money. But you have a bigger problem. You're a nurse and you can't get a job because nobody's going to hire the person that was accused of killing 4 babies. But if there was no reason to bring the charges against her, like if they dropped the charges at the preliminary hearing, the question has to be on her behalf, why did you ruin my life? So she wants to sue the Crown. And the tort is malicious prosecution. The prosecution was undertaken in a malicious manner. So there were 2 questions for the Supreme Court when the case got there. One was, can the Crown be sued? So again, to be clear, the Crown is the prosecution. And the Supreme Court said yes. The next question is, simply put, is Nellis successful? And the answer was no. But the court laid down 4 elements of a claim for malicious prosecution, which I've outlined in the notes. 1, the proceedings must have been initiated by the defendant, the Crown, or the police. The proceedings terminate in favor of the plaintiff, so withdrawn charges would satisfy this, as it was in Nellis. There's an absence of reasonable and probable grounds for bringing the charges, and the prosecution is being brought forth for some reason other than the pursuit of justice. So Susan Nellis would argue that I was only charged, and this is like every episode of Law and Order, I was only charged because there was public attention on this case and the Crown and the police felt like they had to do something, so they charged me. So there is no reason to charge me. That's what she'd be saying for the 4th one. So she loses here, which, not to be too cynical, isn't entirely surprising. It's not entirely surprising because, well, let me put it to you, why would the Supreme Court, for policy reasons, be reluctant to find the Attorney General, in this case, liable in malicious prosecution?
Everyone would sue.
Everyone would sue. But even more to the work of the Crown prosecutors, there's a public interest in Crown prosecutors proceeding with their work without fear of being sued. Put another way, it's against the public interest if Crown prosecutors are reluctant to bring charges for fear that they will open themselves up to a future malicious prosecution claim. So that's why I say it's not entirely surprising. But that said, I still have a lot of sympathy for Susan Nellis. I don't know what she did afterwards or anything, but, you know, this is the kind of stuff that if you study a lot of criminal law, people who are wrongfully accused, this is sort of the area that that work is done in. You ruin somebody's life by charging someone. And the expectation is you have grounds for that. And in the Nellis case, they clearly didn't. So then,
So there is no compensation at all?
nobody's won yet. There can be compensation. So if we
But
look
only
at,
if we prove the malice.
yeah,
So without.
well, if you prove all four.
All four. But malice is a matter.
I don't know if that was the most difficult. I think it would have been the reasonable and probable grounds. Because that falls a bit more within the purview of the prosecution's judgment.
We have discretion.
Yeah. But if you're looking at, well, what would you win? If that's kind of what you're asking, what would you win in damages? Take a look at those who've been wrongfully convicted. And you get a sense of what people will be seeking.
I just add that Joanne McLean is one of the lawyers at our office, and she's one of the founding members of the Innocence Against, which was a WIC association.
Yeah.
That's how we met for long. But so currently, there's a civil suit for Walteridge in prison. I think we're in the tune of, I believe we've got 7 to 9, I think we call it that. We're in the tune of 2.53 million. So it's-
Yeah.
that's
Well, I
kind of
forget
where
what
we're
he
at.
got, but David Milgaard is sort of the
Yeah.
classic example.
Yeah.
He was incarcerated for a couple of decades, I know.
Joyce comes all the time to Joanne's place and does talks.
Yeah. So if you're looking at what's at stake, those are the kinds of figures that you'd be looking to. Yeah.
So there's a distinction here between sort of wrongfully accused and wrongfully convicted.
Yeah, so what I'm talking about is, we're into this whole realm of people who have been put through the criminal process wrongfully. Nellis was never convicted, they dropped the charges early, but Constantina's question was kind of along the lines of, well, if you did win, what would be the damages? And what I was trying to do, because nobody's won yet, was trying to characterize, well, this, if you look at like a David Milgaard, you wouldn't get what he got, but maybe a portion of that for what you went through. That's what I'm looking at, in terms of the, quantifying the damages to some extent, or making it a bit more tangible. So I'm not saying we treat wrongfully accused the same as wrongfully convicted.
So there's nothing for wrongfully accused.
Just this test that has been modified, and I'll talk about the modifications. As far as I know, nobody has won against the Crown for malicious prosecution. But we will talk about how you can win against the police.
If you'd allow me the indulgence to be facetious, the hard law sometimes doesn't have such a bad outcome because she's got an honorary doctorate from Queen's University. And,
Susan Nellis.
Yeah. And seems to have done okay. She now talks about
I still
it.
wouldn't want to trade places with her. And like, honorary doctorate or not, like, she went through hell. That's the kind of stuff that I wouldn't wish on anyone. So I may stand by what I said on that. So on the third point regarding absence of reasonable grounds, we have the Miazga versus Cavello estate case that modified, the Supreme Court modifies the test of it to say the reasonable grounds test for Crown prosecutors should be based on an objective assessment of whether there were reasonable grounds to initiate and continue the prosecution. The way the Supreme Court did it in Nellis was it allowed for subjective assessment, which arguably gave the Crown more leeway. Because if it's subjective, and Roy McMurtry says, I thought we had enough, then it's hard to disprove that. But an objective assessment has been now made the standard. Malice can be inferred. So the O'Neill case, the court stated that malice can be inferred in the lack of reasonable and probable cause in appropriate cases. So that fourth point, if there's no reasonable or probable cause, the court is saying you can infer the fourth element. Then it gets interesting, I think, because it expands somewhat. So liability of accusers. We have McNeil. And I'm laughing not because it's funny. McNeil worked for Brewers Retail, and there were thefts at his workplace. And for some reason, Brewers Retail told the police that it was McNeil. They failed to give the videotapes or the surveillance discs over to the police that showed he didn't do it. So the question is, I know we have malicious prosecution, that deals with the Crown. But what if the Crown and the police are only following a key witness or a key testimony, like in Brewers Retail? Can you sue Brewers Retail? And the answer is yes. And McNeil got $2 million. Then we have the case of suing for negligent police investigation. Now, those of you that are familiar with UK law know that nobody has ever successfully sued the police in the UK. That's different in Canada. And there's a Jane Doe case, which we'll talk about, I think, in a minute. But for our purposes, there's the Hill versus Hamilton Wentworth case that said, the Supreme Court said, we know there's malicious prosecution, but below that, we're going to recognize an action for negligent police investigation. So this is a big deal. And I guess one way to put it is, there's a famous case in the UK called Groves. And, Lawrence, Stephen Lawrence. Stephen Lawrence was walking with a friend home. Stephen Lawrence and his friend were both black males, young black males. And a few white guys came up and started beating them. And they beat Stephen Lawrence so badly they killed him. The police really mangled the investigation. They treated it as if Stephen Lawrence and his friends started the fight, and it was all their fault. And the House of Lords did not find any sort of liability from the police or anything in that case. I mentioned that to contrast with the importance or the precedential nature in the common law of Hill. Hill is setting out the possibility that you can sue the police. You don't have to go to the Crown. If the police are the ones driving the bus, so to speak, on the investigation and charges, then you can sue the police for negligent investigation. In the UK, they don't want to do it for policy reasons. They say police will practice what they call defensive policing. That it will slow down police work, it will make police overly cautious, and they won't do their job correctly.
But there must be a framework, when we have discretion, but there must be some limits to it.
I'd agree, but
We can have some reference to their decisions up to a point.
yeah, and in the UK, they haven't looked into that scope. So maybe another example is what's happened in the US with individuals in custody dying. And there's no liability there for the deaths. So I'm pointing these examples out to show how much of a landmark Hill is within this discussion. think we look at it later. I mentioned Jane Doe. Have you heard of Jane Doe? You might have done it in Foundation. So Jane Doe, forgive the term, have you heard of the Scarborough rapist? Okay, so this came out of the Scarborough rapist case. Jane Doe was the victim of the Scarborough, a victim of the Scarborough rapist. The police knew that he was operating in Scarborough, and they didn't inform people in the area. So to overstate it, they used young single women as bait, so to speak. Was the allegation by Jane Doe. And she said, if I knew he was operating in the area, I would have taken these extra precautions. I would have either walked with somebody here, whatever the case may be. It's a trial level decision, but it was monumental because it was, I think, one of the first times the police had been found liable in tort to a victim of crime. Because she said, you used me and I became a victim because of your tactics. So I just mentioned that because I referred to the Jane Doe case. I think it comes up maybe a bit later, but I didn't want to leave that left out.
Well, we come across wrongful death cases as well.
Wrongful death?
So I know it's pretty common in England as well. In one case I saw a guy who was as a result of police negligence. Do you recall the Steve 6 case, I think? The one where it was like a 911 operator, I'm not sure. Michael, sorry.
Yeah.
So that was within tort as well, wasn't it?
Yeah, but so Balcar is referring to the line of cases that I was talking about from the UK. So Michael's, just because he mentioned it, Michael's is a case where this woman was being terrorized by an ex-husband or ex-partner, and she called what their version of 911 is 999. She calls 999 and says, my ex-partner just came. He said he's coming back with something to kill me.
He caught her with another man. He said he'll come back and kill you after I dropped him off.
Yeah. So she calls 999 or 911 and says, this is what's happening. And for whatever reason, the operators really mangled the whole process. They misclassified it. They said it wasn't an urgent matter. And so police didn't get there until well after, is my understanding, and the guy killed her. So the issue that went to, by this time, the Supreme Court was, well, can you sue the police service? Because I think this was part of the overall police service, the 999 operation. And the court said no. So roughly for similar reasons that I said about defensive policing and so on, they don't want taxpayer money going to damages and work. So we won't be touching those because we don't have that to the same extent in Canada.
Yeah, I think in that case too, ultimately, because it's kind of weird because it's a result of like the Human Rights Act of 1998. So
yeah, so
they were like scratched.
Yeah, so there were rights arguments about right to life, I think it was, Article 2.
Article 2, yeah.
That were thrown in there. That's part of what grounded the claim. So we're not looking at that here. We don't have that kind of apparatus here. Those cases don't come up in the same way. They'd be along the lines of Hill.
Like, I think malfeasance is called, public malfeasance.
Potentially. We're not going to look at that though. Intentional infliction of nervous shock, unless there are other questions about malicious prosecution. So intentional infliction of nervous shock comes from this one case called Wilkinson and Downton. And today the person might say, well, it was only meant as a joke. So this guy comes up to the wife of another man who says, your husband was involved in an accident, you have to go immediately to bring him back home. And it wasn't true. And she became, it was called nervous shock at the time. We might call it today like a nervous breakdown or a mental breakdown. But she suffered mental distress of a severe kind. So the idea is, well, can you sue for that? And the court found that you can. Now, part of the difficulty is there wasn't necessarily an intention here. But this is where a good example of sort of this broad idea of a wrong comes in. The court seemed to feel as though that Downton had committed a wrong that should be redressed, especially given Ms. Wilkinson's state. And they sort of imputed intent here. And as I say, I think there's a bit we can argue about that, whether or not that should be imputed or not. But if you recall the Bettel versus Yim case, the battery case that we looked at, I think the thinking is somewhat similar in that the court is saying, well, you intended to do this, and anything that ensues from that wrongful act is your fault. It doesn't matter if you intend the exact outcome. I think that's how they're working through it. Now in the UK, this case really hasn't gone anywhere, but it has in Canada. And we can see, I've given you a few cases, Purdy and Wojnarowski. Female plaintiff suffered nervous shock when the defendant punched her husband in the head, knocking him unconscious. There's liability here because the defendant should have foreseen the impact.
Excuse me.
Yeah.
Is there, when does the question of remoteness potentially arise, or does it not arise in the case of an intentional tort?
Negligence.
Only negligence, so that it wouldn't arise in these instances. Thanks.
Yeah, I think the case is kind of, so the defendant, in Bilecki, the defendant started a rumor that the plaintiff's son had committed suicide. This reached the mother, who suffered nervous shock and became physically ill. The court imputed intent on the defendant. Radowskis, the action is brought by the father of his 5-year-old daughter for her raped by the defendant. Focus was on the mother's claims for nervous shock. It was denied in this case.
But why? I didn't get why. This one is much more severe than the first one.
I think I'm not 100% sure what. I should say. What I think they were concerned about was the tort becoming a bit too expensive. And we'll see this next week when we look at duty of care and negligence. The courts sometimes take the view that tort actions, tort in particular, can become too big. And what I mean by that is the threshold to meet a successful tort claim is just too low, or too many people can sue in tort. And there's a need to rein in the scope of the tort actions. I suspect that's what the court was doing in Radowskis. because I think it's hard to say what was of the time, because Valevsky was 30 years before, 35 years before. And then we have the more recent cases. Rahim Tula says that the test is applied in Prinzel versus Baycrest. Mustafa versus Culligan we'll see next week in negligence, psychiatric distress as a negligence action. But I wanted to finish up this topic with the Boucher case, because I think it's an interesting expansion of the tort. And it basically centers around what I'd say we call workplace bullying. Boucher was the subject of a 6-month campaign that forced her to resign. And she said, well, this caused me nervous shock. The Wilkinson and Down control. And the court recognized $100,000 in compensatory damages for the intentional infliction of mental suffering, plus $200,000 in aggravated damages, plus $110,000 in punitive damages. So just on the tort, she made what, $410,000 on the tort claim for intentional infliction of mental suffering. Now, I suggest that this is an area to be aware of, especially if you're going to practice in tort or corporate commercial law where there's a workplace involved. In Canada, the cases involving mental suffering or psychiatric distress seem to be treated a bit more openly, or I hesitate to say it, but leniently right now. So depending on which side you're on, I would keep that in mind. If you're on the defendant side, you have to keep that in mind for how you approach the case. On the plaintiff side, you have scope to make what could be successful arguments. So this is just a small example. We'll see a bit more with Mustafa and Sadati next week with psychiatric distress. Then the last topic, this will introduce us to Monday's class as well, protection of privacy. And protection of privacy has been a very odd concept in the common law. Largely, it hasn't been recognized as a tort action. So it's not like you can sue for invasion of privacy. And I'll go through briefly why that is. So in the 70s, we had the Motherwell case, where a daughter seemed to really dislike her mother and made harassing phone calls to her. And that was treated as an action in private nuisance, not privacy. Because at the time, privacy wasn't really an action that could be used. So Motherwell shows that what we today might call privacy, through time has been called different things depending upon the era. Lippick and Borsa in the 90s, the camera focused on the neighbor's backyard, plaintiff's privacy was lost, and the court found for the plaintiff. So the idea is here, if you have a security camera that, let's say at your front door, but you position it that it captures your neighbor across the street and all the people walking by, arguably you leave yourself open to a privacy action. Because the thinking goes, if it's for security, you'll need to point the camera at your laneway, assuming it's a house, and the doorway, you don't need to necessarily reposition it. And I'll give you a case where that became an issue at the end. Now, privacy hasn't really been treated very well until 2012 with Jones versus Tuskegee. And the facts are either amusing or unnerving. Ms. Tuskegee had an ex-husband that Ms. Jones was dating, and I can only presume that she wanted to make sure that Ms. Jones was financially solvent, because she checked her banking records over 150 times in a 4-year period. And both these people worked for the same bank, not the same branch, but it got back to Ms. Jones that Ms. Tuskegee was investigating her solvency status, and she brought a claim. She said, "This is breaching my privacy." But it was more pointed than that. She brought this claim for intrusion upon seclusion. And this is the case that I referenced in the tort assignment. And the court defines intrusion upon seclusion as one who intentionally intrudes physically or otherwise upon the seclusion of another or his private affairs or concerns, is subject to liability to the other for invasion of his privacy if the invasion would be highly offensive to a reasonable person. So the idea is intrusion upon seclusion. You have something that is secluded, something that is kept from the public gaze. In this case, banking records. Your banking records should not be randomly accessible to members of the public. So Ms. Jones says there was an intrusion upon my bank records committed or perpetrated by Ms. Tuskegee. And she won the claim and was awarded $10,000 in damages, which was called a midpoint award. And I think what the court was saying was, this would be, if we had a scale, 10,000 would be about the middle of that scale. Then we have statutory protection of privacy. There are different cases. Different statutes along that. I've given you the cyber safety case. Privacy, and why I gave it to you as an assignment, and unconscionability for that matter, is I think these are areas that are going to expand somewhat or be topical. And what I try to do with the assignments and with the classes is help prepare you for practice. And part of that would be looking at emerging areas or topical areas. Privacy is a topical area. And in my opinion, it hasn't been well handled. Privacy started as a legal issue in the 1890s by an article written in the Harvard Law Review, which complained about cameras and what we might call now an invasion of privacy. We really haven't moved much further than that today. The question I pose to you in the assignment is, how useful is Jones and Tuskegee?
When is this article? In the 90s?
1890s. And it's referenced in the Jones case. How useful is this action of intrusion upon seclusion is basically my question. And I'm asking you to look at, well, what has happened since then? So if you're in practice and you think you have an intrusion upon seclusion or generally a privacy tort action, the question would be, well, what do I do? And I suggest you take a look at the cases stemming from Jones to help in your assessment. Now we'll continue this discussion Tuesday. we'll talk about defamation and privacy. And then the second half of the class, I'll start into talking about duty of care. Because it'll take us a little while to work around duty of care in negligence. We'll introduce negligence and talk about the history of the duty of care test. I don't normally talk about the history, but it's important in this instance to talk about the history. So that's sort of a brief overview of privacy in Canada, but we'll pick up the discussion next week with the meeting there, and then go into duty of care. Any questions? So you can come to class on Monday, but I think there'll be a low turnout. So I'll see you next Tuesday.